Good evening. It's 7 o'clock, and I'd like to call this meeting of the Urbana City Council to order. Would the clerk please call the roll?
Mr. Ammons?
Here.
Mr. Brown?
Here.
Mr. Jacobson?
Here.
Mr. Madigan? Miss Marlin?
Here.
Mr. Roberts?
Here.
Mr. Smythe? Mayor Pressing.
Here. The first item is the approval of the minutes of the previous meeting, September 8th, 2015.
Move approval.
Second.
Motion by Marlin, seconded by Ammons. Any additions or corrections? If not, all those in favor, please signify by saying aye.
Aye.
Those opposed? That motion carries. Are there any additions to the agenda? Okay. Petitions and communications. I have two people that have filled out cards that say they want to comment. So if you would like to say something, please fill out a card. We have it at the back of the seating there on the table, and please give it to the city clerk, Phyllis Clark. Okay. The first person is Bill Spencer from Watch.
Good evening. I'm wanting to speak about the consent decree. At the last meeting that you considered the resolution to pass it, I brought up a question concerning 811 and 302, and I sent you the information. I didn't know if all of you received it and had an opportunity to look at it. But I also wanted to bring up a question concerning the appellate case. I've had an opportunity to call the Fourth Appellate Court and asked them a question concerning the process to dismiss. They said if a motion was made to dismiss the case, that, and it was accepted by the court, that no party would be involved anymore. They would just drop the case 100%. So the concept that it would leave Clinton Landfill and the Attorney General still standing before the appellate court would not be the case. And my understanding is, too, that the consent decree is basically going to do the same thing. It's going to be a motion filed to dismiss. So that's another reason that I don't see any reason to do the consent decree, because that's what it produces, and you can do that without the consent decree. That would leave the case before the Pollution Control Board for consideration. And Clinton Landfill right now is challenging the fact that the Illinois EPA modified its permit for MGP and PCB waste. To me, that's still another moot issue, because the MGP waste has now been changed due to 1326. The PCBs under TSCA, those two are not going to be allowed because of the sole source designation in 811 and 302. The initial filing that Watch made back 8 years ago that stopped everything was the Toxic Substance Control Act does not allow anyone to violate a local or state law when applying for a TSCA designation. So since the sole source has been enacted by the federal government, 811-302 now applies to the federal government too. And they can't ever grant a permit for TSCA, and they're well aware of that. Is there any questions or?
Mr. Ammons.
So, I'm unclear on your motion to, if you could reiterate what you said there. I'm trying to make sure I understand what that meant. From what I heard, if who makes a motion to dismiss?
The you guys, the coalition, you actually are the ones that appealed the case, the decision at the Pollution Control Board. If you decide you don't want to go forward, all you have to do is file a motion to dismiss to the court. And if the court accepts that, they dismiss the case. They won't hear it. And so at any time that you want to dismiss it, you have the opportunity to just take that to the appellate court, and they'll consider whether or not to dismiss it. And normally, they wouldn't have any reason.
But
You're-
that would have to be the entire coalition, not just one entity of the coalition.
Since you guys did it all together as one, that would be, you would have to, either if you voted no tonight, then this agreement wouldn't go through. Then the lawyers for the coalition would come back, and this would be one of the options that you could actually say you wanted to do. Just go ahead and file a motion to dismiss.
Dennis?
And so how would that help the case as far as you're concerned? How would dismissing this question?
What's before the appellate court right now is the question, was a siting necessary for the two new waste streams, the MGPs and the PCBs? And the Illinois EPA has already made that decision along with the Attorney General because they've already modified the permit for Clinton landfill. So basically, your case has already been solved. You've already got the two top agencies, basically, the Attorney General and the Illinois EPA, that has the authority to make that decision. They've already made it. All you've really done by filing this and stretching this process through is you've caused the agency to go ahead and make the decision you wanted them to make. You wouldn't have had to make all this court push if they would have made that decision beforehand, because they would have went ahead and already pulled the permit. Well, the permit's pulled. So you've got the action that you actually wanted all along.
And so secondly, so that doesn't change the fact that there are some already deposited in the landfill currently.
I agree with that. To me, what you're seeing is a Section 21 violation, which is they deposited hazardous waste without a permit. The choice here can be a very strong punishment or a very small punishment. The punishment that Clinton landfill is receiving doesn't even qualify as a slap on the hand. They're almost getting a pat on the back. And what the public wants is for them to be held more accountable for their actions on what they did. So, yes, the waste is still there. Yes, I'm not happy with the choices that the Attorney General and the EPA's made. I wish that this was a lot stronger to send a message to people to not do this to the government again. But I'm not the Attorney General and I'm not the EPA. They get to choose the punishment that they're going to deal out in this case.
Eric Jacobson?
Are you confident that the Illinois EPA, given a couple of new appointees in the next couple of years who are bound to be rather hostile to environmental protection, will not change its mind and move against us?
I think the problem we're having with the Illinois EPA is they have created a relationship with Clinton landfill or other landfills, and they don't want to damage that relationship or cause damage to that company because they're still supporting the landfill direction. I think that's where we're having this problem at, and that's been ongoing with the EPA. A lot of it just has to do with, are we going to move in another direction, or are we going to continue to support landfilling? I believe the EPA, until something happens and they're held accountable for what they're doing, we're going to still travel down this road. Other places in the state of Illinois have chosen not to privatize landfills. They have moved away from that, and the government's taken over through solid waste management and plans that are put in. Those laws are already in place in the state of Illinois, but a coalition, which you guys already are, you have to make that commitment and step to go in that direction and start moving away from this type of landfilling and move towards recycling. The money that is being spent, the people pay that. The citizens pay that money no matter what. Right now, that money is basically going to Clinton landfill, then Clinton landfill redistributes the money back to the government. I would rather see it the other way, that the government collect the money and you become the bosses and hire people.
But I don't believe you dealt directly with
Well-
my question. Are you confident that if we turn down this consent decree, that the EPA, the Illinois EPA, will not move in the opposite direction and undo some of the safeguards that are in the consent decree.
I don't think they have any way to actually undo what has already been done. Their attempt here is to minimize, that's what I'm saying, the effects to Clinton landfill. I don't think this is really an intention for the Illinois EPA to say we're going to lose in a court case against Clinton landfill and they're going to reinstate MGP and PCBs. Even if they did do that, if it did come to that point, we'd have to go, the agency and the Attorney General would have to go through an appeal process through the appellate court and through the Supreme Court. This would be a direct look at the laws that we have in place. And we're saying that the Supreme Court would then rule that the legislators, the laws that they've put in place, don't have standing. They would rule against the laws themselves. 811 and 302 is definitely in there. And the landfill is already under construction. The other thing, too, that I guess I want to give this to you, and I'll hand it out to everybody. This is a map of the actual landfill where we're at right now. And this landfill is not completed by a long shot. And permits are still going to have to be granted to this landfill to continue to expand it. The chemical waste unit is just fractionally started. And 10%, 20% of it is permitted. The other 80% is not permitted right now. So there's a question whether or not by 811, 302, whether or not it can even be permitted. The rest of the municipal landfill isn't even 50%. The footprint has never been granted. So there's a lot of permits that are going to still be granted for this landfill, and 811, 302 says you can't grant a permit unless you meet certain safeguards for the sole source. So I didn't know if everybody, understood that too. This is an ongoing permit process that is happening. And the EPA is going to regulate one way or another because they are the regulatory agency.
Okay. Dennis?
More. So then the question is still apparently open in my mind, I guess, about whether these MPB, is that the
MGPs.
MGPs,
Uh-huh.
if they were desensitized or cleaned, which would be a requirement before they would be placed into the landfill anyway. But apparently they weren't at the Clinton site.
They weren't stabilized.
If they were stabilized, and could then they be placed in the Clinton landfill? Because now they would be accepted under the standards of the landfill.
Hazardous waste in the United States cannot be landfilled unless it is stabilized to begin with. That's the first law. And then, even though it's hazardous waste, it still has to go to a Subtitle C RCRA facility. Okay, that brings up another point, is in the consent decree, you've talked about sightings and so forth and different types of facilities, but there's never been a restriction put in the consent decree that Clinton landfill just can't walk up and try to get a siting for a Subtitle C hazardous waste landfill, which is what they originally wanted in the first place 8 years ago. The TSCA was just a way to try to do that basically through a backdoor hazardous waste landfill and not have to have a siting or a Subtitle C facility. Subtitle C facilities are limited in the country, obviously. Illinois has only had one, which there was in Peoria. Clinton landfill tried to get a Subtitle C siting and permit in Peoria, and Peoria turned them down, did not want to expand their hazardous waste landfill. And they also, at the same time, were doing a TSCA application that they had turned in, a letter of intent, to the U.S. EPA, and they pulled that letter when they didn't get their expansion on the hazardous waste landfill. So what they ended up doing, they came to Clinton and applied to the federal government for TSCA, but they didn't have a hazardous waste landfill. They were attempting to convert a municipal solid waste unit to one. So.
Okay, I think we need to move on. We have other
Okay.
people that would like to talk, but thank
Okay.
you very much. David Noreen?
Hi. I sent you an email earlier today, so I hope you all got that. I'm sorry I didn't get it out earlier, but I was working on that desperately all day to try to finish it up. What I wanted to do is kind of look at some of the things that came out in the Saturday session and some of the things that I've been trying to think about for some time. And what that has to do is, back in January of 2010, there was permit modification number 9, and this was the ruling by the IEPA official that high-level PCBs could be brought in and high-level MGP waste could be brought into the Clinton landfill. Now, most of the attention went to the high-level PCBs. That got everybody alarmed right away, and that was fought. But it seems like people kind of ignored the high-level MGP waste, okay? And the landfill has emphasized, well, we never even had a federal permit for high-level PCBs, so we really couldn't have brought them in anyway, so there was never anything brought in, and that's true in terms of high-level PCBs. But they also would have needed permitting to get high-level MGP waste in there, and they wouldn't have been able to get it because the federal government does not allow you to put high-level MGP waste in the ground. That's prohibited. The pamphlet I sent you a link to describes the procedure that goes on, and that is when you have high-level MGP waste, you have to remediate them. You can either remediate them at the site they're at, where you find them, or you can actually haul them away to some specialty place that remediates them off-site, but you cannot put them in the ground. And I think that whole point has been missed in this kind of debate. I think even the Attorney General has gotten some bad information, because one of the things that was put out in that part of the argument was, well, Clinton landfill is engineered to a chemical waste standard that has 3 liners, and you only have to have 2 liners for a hazardous waste landfill. But the point is, even the hazardous waste landfill would not be able to put the MGPs in without remediating them first. And the reason is, and various people have been testifying about this in public and trying to explain it, is that the MGP waste, if it's in high levels, it degrades the liners. And so, you know, people wonder, why would any landfill be willing to put high-level MGP waste in there if it's going to degrade their liners? It just doesn't make sense to do that. And so it seems there must have been, you know, somebody at Clinton Landfill who really wanted to establish their chemical waste unit, and they wanted to get a lot of chemical waste in there very quickly, because if you look at that table I gave you last time, in 2011 there was a lot of waste that was put in there very fast, and it came in big amounts. 3/4 of the chemical waste that's in there came in there in 2011. The funny thing is, the places where it came from, Ameren and ComEd, they know that they have high-level MGP waste. You know, it's sitting there, and they got to get rid of it. And they know they're supposed to remediate it before they put it somewhere. So, you know, there's a lot of wrongdoing going around, and we shouldn't, you know, overlook bad behavior. To my knowledge, you know, people haven't been looking at that aspect of the problem, that if there is remediation done, either at Clinton, if that's possible, or elsewhere, it would seem some of these companies that got a bargain by not remediating their waste before it went in should have to pay for some of that. But there's funny things going on. I think the EPA in Illinois has been under pressure to try to find a place to put bad waste that's piling up in the Chicago area. And so they want to find a place where they can put this stuff. And, you know, in some respects, Clinton would be a good place to put it if it didn't have the Mahomet Aquifer sitting underneath it. It has the support, apparently, of DeWitt County. You know, the board keeps, you know, backing down and not fighting because they know that they lose the tipping fee that they get, which was recently withheld, you know, by a unilateral decision by the landfill because DeWitt County didn't seem supportive enough. And so in order to get that money back, they kind of have to go along with
You have 1 minute, Mr. Noreen.
Thank you. What Clinton Landfill wants to do. So anyway, if I were the person in the IEPA that made this mistake that allowed the manufactured gas plant waste to come in the landfill, I'd be surprised if I still had a job. And yet this person is still working for the IEPA and is one of the persons listed on the people who get notifications from the court about everything that goes on. So there hasn't been any kind of investigation of this. There's all kinds of things going on here. I'd like to remind people that the Attorney General has a dual role, not only to protect the people of the state of Illinois, but also to protect the agencies. And if somebody really messes up very badly, the Attorney General's office would be responsible for defending that person. And so I think some of the things you see here, there's a certain defensiveness by the IEPA, but also the Attorney General's office, because they have to defend them.
Okay, thank you. Aaron?
So, David, tell me what you would like to see happen.
Well, what I'd like to see happen is actually a further delay of this. I know that's hard to do because it would take a supermajority, but I think we're just starting to get at a lot of these issues. Like I asked the question at the Muhammad Aquifer meeting, how is it possible that this Illinois EPA official could even grant a permit to put high-level MGP waste in there, because that's against federal law? How can an Illinois official say, I'm giving you a permit to violate federal law? I simply don't understand that.
And I think that you and Bruce and the rest of the watch are doing an excellent job of raising the concerns. But as we talk about going forward and how to actually address the concern, because we don't want the PCBs or, the MGPs that are there to stay there, right? I understand that. But I don't hear from you guys, what is the plan to get rid of them? If we're saying this plan is not going to get rid of them, then what is the plan to get rid of them? You understand what I'm saying? That's the concern that I'm having. And right now, the consent decree is at least stopping anything else from coming in there. I think there seems to be two separate tracks here. There's one to stop anything else from going in, and then another track to actually stop it, to get it remediated, to get it removed. But as much as you guys highlight the concerns and the inappropriate actions that took place to get it there, I still don't hear a plan on how to get it out.
Well, I think those plans will be forthcoming. Like Albert Ettinger, when he spoke both at the Champaign County Board and here, he mentioned RCRA and how Maine had actually filed a suit and had gotten won it based on imminent danger. That the danger hadn't happened, the actual damages hadn't happened yet. But in this case, there was such a great imminent danger that they were actually able to win the case under RCRA. Now that's one possibility. I'm not sure, like there's problems with state law and federal law, and I'm worried that, the consent decree looks like we're saying, okay, we're willing to just leave this in the ground forever. If we're saying that, is that going to damage other things like, another suit by the federal government through RCRA? Ideally, I'd like to see some kind of investigation go on, because it seems to me we're just covering all these things up. And
Well, I would like to say that the Coalition of Governments is committed to going forward and changing state law and adding many protections. And I know that one state representative has already introduced a new bill. So we're not going to just say, just leave it the way it is. We want stronger laws, but our attorneys tell us that this is the best we can do under existing law. So that's why we are doing this. But we take your concerns seriously, and we are committed to moving forward. Any questions? Okay, thank you so much.
thank you.
Bishop King James Underwood and Reverend Dr. Underwood would like to be recorded as being concerned about the Ellis subdivision sewers. Spencer Haydery, is that your name?
Hi everyone, my name is Spencer Hayder, and I want to introduce myself as the new Urbana City Council Student Liaison from the U of I Student Senate. And I just wanted to say that we have a lot of exciting initiatives just springing up right now that I'll be sure to keep you all up to date on. But I'm also really excited to work with all of you to align the city's goals with that of the Senate and the university. So I'd be happy to take any questions that you guys have right now. Otherwise, I'll be sticking around for the duration of the meeting.
I admire your stamina. Eric Jacobson.
are there, don't give a long answer to this, but just off the top of your head, are there one or two issues that the Student Senate is really concerned about that might might be overlapping or synergistic with city concerns?
Great question. So we do have a budget crisis with the state of Illinois, and there's talks about a 31% cut to our budget. And so one of the proposed solutions, some of the rumblings that have been going on with the university, is that we're going to have to increase enrollment. And with increased enrollment comes increased housing. And as a response, we actually just approved a new committee on housing and urban development. So that's definitely something that we'd really be interested in working with you all on to address.
Thank you very much.
Thank you.
And welcome.
Thank you.
Eldris Melinda Carr does not wish to speak, but she also is concerned about the Ellis Drive sewer issue. Is there anyone else who would like to address the Urbana City Council? Okay, we will move on. Unfinished business, resolution number 2015-08-047R. Yes, okay, go ahead.
First and foremost, this is really out of character for me to speak at this city council and say anything of any greater importance to me than what our proper protocol is for being an elected official and sitting on the council round. I am highly upset and I feel very disappointed in the fact that our elected official, Mr. Jacobson, would sit on this council round with a hat on his head. We teach our children that when they enter a room, especially a male, that they should remove their hat when they come in. But we have an elected official who sits on this council round where this body is elected by the people with a hat on. I find it offensive and personally distasteful. That's all I have to say. Thank you.
Okay. We are at unfinished business, resolution number 2015-08-047R, a resolution approving a consent decree to settle all claims in a citizen's complaint filed with the Illinois Pollution Control Board by the City of Urbana and other units of local government against Clinton Landfill Incorporated. Mike Munson.
Just for your information, I provided a paper copy of the resolution, just in case you wanted to refer to it. There's been no changes from 2 weeks ago.
And if anybody has a question, we have our attorney from the City of Champaign, who I would imagine would be willing to answer any questions that you might have.
Yes.
Do you want to come forward? Any questions? Charlie?
Yeah, I think Diane and I both went up with our hands here. My
Okay.
question's for Joe in particular.
Joe Hooker?
Yeah, okay, yeah. Joe, we keep hearing about this unremediated waste. Is that substantiated or not?
I'm sorry, I didn't hear the question.
We keep hearing about this unremediated waste, MGP waste.
Unremediated?
Right. Yeah,
From
is there-
Mr. Doreen, you mean?
Yes, and others have mentioned the
Well,
same
I
thing.
don't frankly know precisely what he's referring to when he says high-level MGP waste. That's clearly what not was being applied for at this particular location, and certainly the state cannot disregard federal law. So he may be referring to a form of that waste that's not sufficiently solid or in a proper form, and what leads me to believe that is when he says it can't be buried anywhere, even in a hazardous waste facility. So he's clearly talking about some form of that waste that's not related at all to what the Illinois EPA initially granted permission to do here. I can't speak to the specifics, but it's clear to me that he's referring to some waste that's not even relevant to our case.
Okay.
Diane? Okay,
and
go ahead.
There's two related questions with this. If the liners were to be degraded, that would show up in the leachate that's being collected in the monitoring wells, wouldn't it?
It would.
Okay, and
It would,
then,
and there's, and just on that point, there's of course redundancies. There's several layers. There's clay between the layers, and so there's.
and there's collection at different points in the layers then?
Pardon me?
Is there collection at different,
Yes, there's a
the-
leachate collection system under each layer.
each
That's
layer?
correct.
Okay, so, if Watch wanted to pursue a claim, or others wanted to pursue a claim that there's unremediated waste here that violates federal law,
They could pursue that.
They
The
can pursue
consent
it.
decree doesn't interfere
Yeah.
with that at all.
does the consent decree interfere with us pursuing something like that?
No,
As the
that would be
the coalition?
Well, it gets back to my original point. The waste we're talking about is clearly not the waste he's talking about. That's as clear as can be to me. And the notion that somehow, well, so I don't think it would prevent us from doing that if indeed there's some waste there that is not the MGP source material. That's the source of our lawsuit. He's suggesting that somehow waste has been put in there that it's not MGP source material. Because MGP source material, it's very clear in the law, until very recently was even a non-hazardous special waste that could go into any landfill. And so now it's a hazardous waste that has to go into a hazardous waste landfill. So I think the short answer is yes, that could be pursued if someone could come up with evidence that there's this other type of waste rather that's gone in there rather than what was allowed in there through the original IEPA permission.
Okay, thank you.
Diane?
I'm good.
Okay. Eric?
Do you feel that the monitoring wells, well, in the first place, let me ask, are the monitoring wells, the specifications of the monitoring wells, are those established by law?
Yes, yes.
And in your opinion, are they adequate to catch a problem before it's before it will irreversibly
I think
contaminate
so. I'm not the best
aquifer?
person to ask that. The well regulations have been in place for quite some time, and certainly they're designed in order to reliably catch contamination before it gets down to the next level or the next level or next level, let alone the Muhammad Aquifer, some 150 feet below. So, I can't speak to whether perhaps the regulations might be improved somewhat, but in any event, we can't accomplish that with our litigation, and certainly can't reasonably expect Clinton landfill to be the only landfill in the United States to agree to enhanced requirements. So,
Dennis?
I want to go back to your comment about how the MGP,
MGP.
yeah, waste that was deposited legally wasn't toxic at the time, but now we consider it toxic. So now we're concerned about it, but it got there anyway, whether it was legal or not. So you're saying that that's not an important consideration?
I'm not sure what you mean by not an important consideration.
It means that we're not concerned that it was allowed to be placed into the landfill and it still exists there at this moment?
I'm not saying that in a perfect world or in an optimal sense it would be nice if it wasn't there. My point has been consistently that because the Illinois EPA did grant a permit modification to authorize it, I don't think there's any court in the United States that would order that to be removed. That's my point. Not that sure it'd be great if it wasn't there. And I guess I remind everybody that it is about 1% of the current capacity of the chemical waste unit. But I agree it'd be great if it wasn't there. The real question before us, I would suggest, is whether we could accomplish that with getting that removed with a lawsuit, and it's my firm opinion that we can't.
Okay. I just wanted to, I guess for my clarification, I didn't want you to denigrate the fact that there was a point made that something that we don't allow today was allowed earlier by apparently mistake or ill advisement.
Well, and I have to say, and this gets back to the complexity of the lawsuit, and again, I sure don't want to be misunderstood. Would I rather that stuff not be there? Absolutely.
Okay, great.
But
I agree with you.
well, let me finish my thought. There's actually a legal dispute about whether that was mistakenly granted to begin with.
Right.
And that's still our lawsuit that, we lost that at the first stage. The landfill argued that it was not, in fact, a new pollution control facility. That didn't seem logical to us, but the Pollution Control Board agreed with them.
Right.
And so that's still a matter of a dispute even. So that's another level of uncertainty about going forward, is my point.
As far as maintaining the monitoring of the landfill currently, who will pay for that? Do we know clearly who's paying for it? Will the consortium be responsible for part of it? Is this totally?
No, the landfill has to monitor it. They're responsible for complying with all of the monitoring requirements. They have to report the results of those per regulations at regular intervals to the Illinois EPA. They pay for all of that, and the Illinois EPA has to review all those results.
And is it known what the likely degradation of the lining might be if indeed these toxic elements that may or may not have been deposited legally, how long it takes for them to reach the layers that we're going to be siphoning?
There's a lot of disagreement about that among people with credentials. You could spend the next 2 months reading studies about whether HDPE liners keep it there for 30 years, 60 years, depending on the concentration of the waste. I'm sure not the best person to ask that. The only thing I can suggest to you is that it's a matter of a lot of controversy, and again, it's not something we could have changed with our lawsuit anyway.
Because the lining's there and
Because the liners were
permitted.
permitted by law.
Right.
I mean, just to put a fine point on it, I mean, not because I like the liners or that there isn't some controversy about them, but the fact remains that there was nothing unlawful about that.
By going ahead with this document, if we were to pass this, would we be bound, or would our hands be tied to try to alleviate the problems that might occur there in the future?
We would not be permitted to ask for the single remedy of removal. The Illinois EPA and the Attorney General's office, or any other citizen for that matter, could ask for that. And but other than that, we have the full spectrum of civil and criminal sanctions that we could seek for any future violation.
Do you want to explain that the city or the coalition could seek criminal?
Well, you know, I don't know exactly if we could seek criminal. We're given that right if it exists, let me put it that way.
Right.
And we're given the full, it's probably more likely that we would be seeking something that would be characterized as civil, as opposed to somebody going to jail, for example.
Right.
But the consent decree in a number of locations makes it clear that we reserve all those rights.
Okay.
And we have had new legislation introduced to change and tighten up the monitoring process.
I
That was
don't know
Chapin
that
Rose
we
that-
have. I think people have been looking into that. There's
I
been
think Chapin
there's been a
Rose
lot of
announced
bills.
it.
Chapin Rose is thinking of doing that, I
He
think.
announced it recently.
Okay, that could be. There's been a lot of bills introduced. It's kind of hard to keep track of them all. But that, again, I wouldn't disagree that might be something to take a closer look at.
Okay, Aaron.
So, Joe, thanks again for doing all the work that you guys are doing. And I know it's a tough spot for you to be in. So I just want to ask a couple of different questions. Hopefully I can get a little more clarity on this. Because the major concern for me, I believe, is the cleanup part afterwards. I understand that the lawsuit, from your expert perspective and your years of service as an attorney, you do not feel as though any judge will grant remediation as a part of the lawsuit. Who determines if a site needs to be remediated? Who has the authority to determine that?
The primary authority rests with the Illinois EPA, no question about it. Their view on this is going to be given, I think experience shows, the most consideration. They are the permitting agency. They're the ones who typically bring a lawsuit. They would bring the lawsuit through the Attorney General's office. And the consent decree continues to reserve every remedy available under law to the Illinois EPA and the Attorney General's office. And for that matter, anyone else, any other citizen who could show they were affected could bring a similar lawsuit and seek even exhumation, removal of the waste. I think the key is that, as a practical matter, that that very substantial remedy is never going to be enacted without the vigorous action of the Illinois EPA, because they are the permitting agency, they are the primary enforcer, along with the Attorney General's office.
And so,
So I understand that there was a little trade-off there, and but you know, it's our view that as far as real-world consequences, that's not going to affect the likelihood that ultimately a court would order it to be exhumed. And the experience is that you would need the Illinois EPA and the Attorney General's office saying that that's essential in order to address the problem. So
I just had a few more things. So if I understand what you just said, the Illinois EPA would be the agency that determines whether or not a site needs to be remediated.
well, initially, ultimately, someone not happy with that might seek a relief from a court
Okay.
and say that the administrative agency wasn't fulfilling their responsibilities. And I'm not the expert on that. I'm not sure precisely what the standard proof would be, but that's kind of the general outline. Initially, it would invariably be the Illinois EPA acting through their attorney, who's the Attorney General, the law enforcement agency for the entire state. And they would be pursuing it. The Pollution Control Board would actually be the first body that would order it in the manner of a court. And then if an affected party was not happy with their judgment, they could appeal that to a court. But likely the Pollution Control Board's decision would stand one way or the other. They're given a lot of deference about fashioning remedies for a violation. If that kind of gets at the question,
It
I
gives me
understand
some.
the question.
I'm just trying to understand.
Yeah,
And of
yeah.
course, the Illinois EPA is not a part of this coalition, so they would not be. There would be no gag order, so to speak, on them. They would be able to act as the agency that the
Well, and
protection
they-
agency that they are. Right?
They are actually a part. They're not part of our citizens' complaint, but they are part of the consent decree because they have the parallel lawsuit where they're now defending their action of changing their mind and saying there should have been a local siting hearing. So it's kind of a weird, it's an unprecedented, very complex set of litigations. I mean, I don't know how else to put it.
Well, for me,
But they are a party to the consent decree, the Illinois EPA and the Attorney General's office, and very explicitly it reserves all of those rights in them, and the Attorney General's office and the Illinois EPA insisted on that. So, I mean, I know they've been kind of cast in a bad light here in a lot of ways, but, they're the ones who changed their mind, too, and we're happy they did it. And, we had some political pressure brought to bear, and so, they will listen. I mean, if they miss something, it's not like they're completely immune to doing, the public service and protecting the environment. I think they made a mistake here. I think they dropped the ball on the original permission, but I give them credit for changing their mind. Not an easy thing for them to do, and now they're being sued. So it's.
So I mean, I kind of understand where we're
Yeah.
going here. As a clear, for me to be able to make sure that my conscience is clear on this.
Yeah.
What I just understood you to say now is that the consent decree binds all 14 agencies from pursuing any particular further remedy as a group, and that the IEPA and the Attorney General are part of that. So in essence,
No, I'm sorry.
Okay.
They continue to have the right to seek the ultimate remedy
all right.
if it's otherwise warranted of having the stuff dug up. And,
Okay.
and that, I have to say, kind of unusual to happen, but not that it wouldn't be impossible, but they would have the right to do that.
Okay.
Yeah, I'm
and-
sorry if I'm confused.
And so
with
I
the
would
word.
like for you to take a moment, if you would, to address something that is kind of interesting to me that Mr. Spencer brought up about the appellate case motion to dismiss. I know this is your domain, so to speak.
Yes.
So if you would, what I heard from Mr. Spencer was that basically these entities could come forth, make a motion to dismiss, and basically the same remedies that are granted in the consent decree would be achieved through that motion to dismiss. Would you speak to that?
I think that's clearly erroneous or wrong. First of all, it's up on appeal before the 4th District Appellate Court, so we would be withdrawing our appeal challenging the dismissal of our lawsuit. So it would go back to the status quo, which is our lawsuit got dismissed. And that basically adapts all of the legal positions of the landfill, including this was not a new pollution control facility and the like. So I respectfully would suggest that's just a clearly erroneous statement as far as the impact of just going to the appellate court and saying, you know, we dismiss our appeal. It reverts back to the quote-unquote trial court, and the Pollution Control Board is kind of the trial court here, and they dismissed our complaint. They agreed with the landfill. So essentially that would adopt the position of the landfill, if that makes sense. So that's just not a correct, I appreciate he made a phone call and looked into it, but that's just not a correct statement of what the impact of that action would be.
My last question is in relationship to subtitle C, hazardous landfill, if you would offer any of your perspective on that. I think Bruce brought that up as well.
Well, I don't remember exactly the context, but they are correct that at some future date, the landfill could make a request to open up a hazardous waste landfill. They would have to once again go through the local siting approval process, and they would have to meet all the technical requirements of the state of Illinois. That's simply well beyond the scope of our lawsuit. So if the suggestion is we should have got them to agree to not do that, it's not something we could accomplish even if we were wildly successful with our lawsuit. So I'm not sure what the specific question is. He's correct in the sense that the consent decree does not prevent them. It does prevent them, however, from ever accepting the TSCA-related PCB wastes, not just in this facility, but anywhere in DeWitt County over the Mahomet Aquifer. And I know now everyone's not everyone. One of the speakers kind of made light of, well, this was originally about TSCA PCB wastes. And if I might have a few minutes to kind of remind everybody how this all got started. He's correct. That was the big fear, no doubt about it. And the reason it was the big fear is we would have been the second landfill in all of Region 5 to accept TSCA-related PCB waste from all over the Midwest. It's a 5-state region. The only facility that can currently accept that waste is just outside Detroit. They have the distinction of being the only chemical waste unit that it can accept PCB waste regulated by TSCA. Big concern we had, and it's clear to us that even though they withdrew their request at this time before the US EPA for that permission, they could renew it any time. There's nothing that would prevent them from doing that. And what this consent decree does is it says Clinton Landfill or any successor in ownership of Clinton Landfill will never ever be allowed to even request to dispose of that waste, not just in not just in the chemical waste unit, not just in landfill number 3, but anywhere in DeWitt County that's located over the Mahomet Aquifer. So, I have to say I've just been kind of flummoxed by the notion that, well, what's the gain of that? I don't understand that argument at all. So it's important to remember that the consent decree prevents that from ever happening again, and we can go into court and prevent it from happening. It also prevents them from ever accepting manufactured gas plant source material, not only in the chemical waste unit, not only in all of landfill 3, but anywhere in DeWitt County located over the Mahomet Aquifer. And again, I would respectfully suggest that's a big plus for us. That's a very strong reason to approve the consent decree. So yes, as a technical matter, they could make a request for a hazardous waste landfill. I think it would be tough sledding for them, in part certainly because this is now a sole source aquifer. I've never disagreed with the notion that that makes it harder. I agree with that. I just categorically reject the notion that it makes it impossible, which is what's been suggested to you. And so and I'm sorry, I completely forgot what your original question was.
Did you get your question answered?
But that's the point I want to make. I absolutely, they could come in and make a request for a hazardous waste landfill, but the only reason they wanted that was for these two waste streams. Now, maybe there's some other obscure waste stream that in the future they'd like to put there. Our lawsuit wouldn't have prevented that in any event, and I can't emphasize that enough. The idea that that would be a reasonable bargaining chip, I just would respectfully suggest it's not reasonable. But I think we gain a lot with this, I really do.
Okay, Bill Brown has a question.
Yeah, I know that the consent decree says that we will never require CLI to exhume the MGP source material, but are there other remediation steps like bioremediation that can be employed without exhumation?
Well, if it can be attempted without exhumation, by definition, the consent decree allows that. I can't speak to what other techniques, if you will, are available, but absolutely anything else, whether it's flushing it out. I mean, there are instances where contamination has been, as I understand it, identified and somewhat localized, and they've successfully diluted it with some kind of process. I'm not the expert on that, but any of that would be available to us, absolutely. It would ultimately be up to the enforcement agency to determine whether that was practical or the appropriate response, but we could ask for it.
What would the mechanism be to go about getting that to happen?
I don't know. I'm sorry, I just don't know. I'm getting into anecdotes, and I don't want to do that. But there's certainly other. I'm fairly confident there's other approaches. They're not easy fixes by any means. I don't want to oversell that, and I'm not the expert on that. So.
Okay, is there a motion? Yes, Diane?
Well, I'd move approval of resolution number 2015-08-047R.
I'll second that.
Okay, there's a motion by Diane, seconded by Eric, and Dennis has a question or a comment.
So I'm still getting information, and Joe, I'd like maybe you to answer. Currently, my understanding is that if the toxic substance that's in question, that's in the landfill currently, is just left there, and we're not going to be able to exhume it, what we're going to what we're apparently going to see happen is that it's going to be covered by layers and layers of municipal garbage, just your standard stuff.
Right.
Is that a concern for future things leaking into the level where this toxic material is left? Would it be better to not put anything there ever again? And is that something that this consent decree prohibits us from asking for?
Yes, it does. And now they've agreed to put a layer of clay soil on
12
top
inches,
of it.
right?
Pardon me?
12 inches, I think
That's
it was.
correct.
Not 12 feet, but 12 inches.
Well, you are correct. The consent decree does not prohibit them from putting additional waste on top of that.
Yeah.
That's correct.
And we don't know what that ultimately might result in if there was seepage through that.
Okay. There's a lot of redundancies here, and as far as the protections or whatever, I can't predict what's going to happen, and I'm not the best person to ask. I think it. So I don't have an answer to that.
Maybe buried is better.
Okay. Anyone else? Diane?
I just wanted to make a comment. Can I do that?
Sure.
Okay. I wanted to read a very short email into the record. This was from Bruce Hannon. It says, quote, "Count me firmly in favor of the consent decree on the Clinton landfill issue. The decree locks out the possibility of much more threat to the aquifer than it might lock in. When the decree is signed, and this part is history, we're all pledged to the long-term effort to turn the coalition into an association as a long-running protector of the aquifer." That's the end of his email. And I just wanted to add that I agree with Bruce Hannon on this. I support the consent decree, and I intend to vote for it. I believe that it does lock out far greater threats to the water supply than it lets in. And most importantly, it'll buy us time to work on those long-term protections that are needed for the aquifer. I think we all recognize that this settlement can't give the aquifer every protection that it needs, but it gives most of what's possible to get under the limits of current state and federal law and within the scope of our lawsuit. So this in my mind is not the end of the story. It merely is the end of one chapter, and we're moving on to the next, and that next chapter has to include very closely monitoring what goes on at that landfill. The Clinton landfill is never going to act in the public interest. They're acting in their own interest. But we have others, elected officials and citizens, and including ourselves, who need to monitor this in the public interest. And we especially have to insist that the EPA and the Attorney General act in the public interest to keep an eye on what's going here, to particularly with regard to testing the leachate and monitoring the long-term effects of the landfill. And there are some changes in state law that we have to go after. I think one of the most important is getting coal ash redefined as a hazardous waste, and that's probably tops on a lot of people's list. I think we absolutely need to prohibit expansion or siting of any other landfills over the Mahomet Aquifer anywhere in the region, not just in DeWitt County. And if Chapin Rose is looking at tightening up some of the monitoring requirements, then I think that's a great idea too. So there's a lot of work to be done, and this consent decree, again, is a step in that direction. And it's when you look at this document and what it does in terms of keeping these TSCA PCBs out of Illinois, it's a remarkable environmental victory. And you wouldn't have thought this was possible just a couple of years ago. So we owe a great deal of thanks to the citizens in DeWitt County who sounded the alarm and who brought this fight forward and carried the fight. And to the people here in Champaign, Urbana, such as the Champaign County Healthcare Consumers and Prairie Rivers Network and all the people working with them. And then the leaders from Champaign, like Joe Hooker and Steve Carter, who led this coalition. This is the beginning of the effort, and but their tireless work has gotten us to this point, and there are 750,000 people who depend on this aquifer who owe all of you a very sincere thanks, and I'm one of them. So I'll support this consent decree and look forward to efforts by our elected officials. And I forgot to mention Representative Ammons and Senator Bennett, who passed the legislation on MGP. So again, we've made tremendous strides, and this is just the beginning.
I would like to point out that in parentheses below the title, aquifer is misspelled, so we need to spell aquifer right. If that would be, someone wants to make a friendly amendment.
Can I amend my own motion?
Yes, you can.
Let's correct that spelling.
All right, is that okay with the second?
That's okay with the second.
Okay. All right, Bill.
I would join Diane in thanking everybody and thanking especially the citizens groups that brought the PCB issue to attention to begin with, and Watch and the Clinton and the DeWitt County board members who were opposed to allow the landfill initiative, especially Terry Hoffman and Sherry Brown and George Wismiller and Bill Spencer, and David Noreen for his input. But I attended one of their DeWitt County board meetings about a year ago, actually in July, I think. It wasn't the one where there was a altercation. It was the month before that. And we've had our dysfunctional moments, and we can be dysfunctional, but we don't get personal very often. And I wouldn't put a whole lot of faith in the DeWitt County board to come up with a solution to this. So I think this is a good consent decree. I think it accomplishes a lot. It doesn't do everything we wish. It would be nice not to have the MGP waste there. But I think the people that presented the case for the decree, frankly, were more consistent. They were professionals, so they had that advantage going for them than the people that were opposed to the decree. The people opposed to the decree, I think everybody acted in good faith, but I think sometimes citizen scientists aren't quite the same as the professionals that understand things. And you can try to be a citizen lawyer and try to understand everything. But I've looked at the regulations, and they're so convoluted. They go back and forth between federal and state and reference different levels. It's hard to understand any of that. So I think in this case, people like Albert Edinger that have been in the business for decades, I think I have my faith in. And so I'm going to support this. It's a really complicated issue. I think there's a lot to learn still as far as hydrogeography, geology, hydrogeology. We understand what happened 400 million years ago and how many layers got put down and everything, but we don't know on a fine scale what's actually underneath these things, unless you want to drill 100 holes there and somehow analyze every hole. You don't know for sure if there's some way for the water to seep down into the aquifer. But you can infer it from a lot of tests, and some of those tests are pretty convincing. And I think that we would risk we would risk something by not passing this. I think they could make the argument that they could have a chemical waste unit there. We also need to work on getting legislation passed and doing more research. Frankly, that's one of our contributions that we can do as a university community, doing more research and remediation, how we understand these toxic wastes, how to deal with them better, even where the recharge zones are. That's part of the laws. We don't even know where a lot of these recharge zones are. How do you define a recharge zone? Apparently the Clinton area is mostly pretty low recharge, but 1 inch per year as opposed to maybe 15 inches per year in Champaign County, but there's some recharge. So is that a recharge zone? I think there's still a lot of questions that need to be answered and laws to work on in the future. So I just wanted to thank everyone, and Joe Hooker especially, for coming several times and helping to fill in the gaps on everything. And I think Claudia Linhoff, when she was here, mentioned how important it was to clean up the Fifth and Hill site, because there the benzene from the waste actually vaporized into the ground and then can get into people's homes through the basement and stuff, and that's when it becomes really dangerous and cancer causing. So no matter what you feel about having the waste in the landfill in Clinton, it's better than where it was. It's better than where it was in Mattoon. 2/3 of it came from Mattoon. And that site was, from all I can tell, pretty much identical to what we had at Fifth and Hill, just a little bit smaller, actually. So just as one final point, I do want to point out the amount of material there in the chemical waste unit, the MGP source material, has been characterized in different ways. I think one person talked about it being enough, small enough where you could carry it off in a few pickup truck loads or something, and then in the newspaper editorial a few weeks ago, somebody said it was several assembly halls full of material. So there's quite a bit of different, but you can use math and you can figure these things out. So as sure as pi r squared equals the area of a circle, it's actually about the size of the assembly hall, the shadow of the assembly hall, to a depth of about 4 or 5 feet. If you do the math, it's a lot of material, but it's not several assembly halls full. So I think that's all I had to say. I intend to support this.
Dennis.
This would be a decision that would be pretty easy to be just on the edge and not quite know what to do about it. I really do appreciate. I think they're really thoughtful and kind of piercing questions that Steve Bridges and David Noreen have brought to us and others in the past. I go back, how we handle toxicity has changed so much since when I was a kid. One of my first jobs out of college was to work in a silk screen shop, and we used to clean the silk screens with xylene, which we applied, barehanded with rags, and we had bottles of it in our shop.
Yeah.
And today, that would blow your mind, but at the end of the day, that's just how you cleaned a screen. That was the technology. I'm alive today, and I seem to be healthy, but that doesn't secure the fact that yes, toxicity does exist in forms that we are aware of. You know, we also should be concerned about, you know, future leaking of these chemicals potentially, because we have a landfill here in the city that's been closed for numerous years, but we also are spending $17,000 a year taking care of materials that are leaching out, and we don't want them to go into the Salt River, Salt Fork. So, you know, these things do happen. But on the other hand, what is the future can be addressed in the future. What's in the past we can't undo. What's the best way to stop it and cap it and make sure it can never happen again? And I think one of the things that I'm that I at least have some value to consider in this is that over the last 5 years, I've seen the concept of the Mahomet Aquifer as being a sole source amenity to this community take on such a strong reality. And so many people are behind that to the point where we now have designated, you know, legislation that designates it as such, that I would hope that this area of our land in central Illinois will always be well protected, certainly way more protected than it was in the past. Just like I would never be washing a screen out with raw xylene again in my lifetime, nor in anybody else's. So we do have these changes that occur, and there are mistakes in the past, and we do have toxic sites in the city because there's been either a dry cleaner or a gas station at certain locations for too many years. But I guess the best thing for me that I would say is that I'm willing to go forward. I guess I'm going to support this. I know that there are questions that can be raised, and I have some doubts, but I think that overall this is the better place to go, and the future can be maybe stronger because if we support this, we might have a better product in the long run.
Okay. Did you want to say something, Aaron?
Yes. So first of all, I want to say that this reminds me of when we were working on this Fifth and Hill site, and one of the slogans that we talked about that we repeated often was that the poor get dumped on. So regardless of whether it's Fifth and Hill, which is a predominantly African-American neighborhood, or DeWitt County, who seems to be under the gun for money and stuff like that, it's all these locations are typically where poor people live, where these sites show up on a regular basis. Of course, you mentioned Detroit, right, and Danville. We see this happen over and over again. And I do believe that Mr. Hooker and David Noreen, I think you all care about the Mahomet Aquifer equally. I understand the pressures that it puts everybody in, and you're trying to do your job, and we're trying to do our job as citizens as well. So I want to thank Watch, Bruce, or I don't know if it's Bruce, I keep saying Bruce Spencer, Bill Spencer, Dave Noreen, all the people from Watch. I hope that we will get back on the front lines and go back to work to finish this job. But I don't want to throw DeWitt County under the bus, because I think they're trying to do the best that they can for their citizens as well, and maybe they made a poor decision. I happen to think we made a poor decision not too long ago. I didn't vote for it, but some other folks did. So, you know, and I do agree with Diane that I think that the concept that this consent decree locks more out than it locks in, I think is important for us to do what we can to protect what we have thus far. So again, I join everybody else in thanking everybody for all the work on this, but at this point I will be supporting it.
Eric?
I don't want to make a long statement. Other people have spoken to this issue very eloquently. I do intend to support the consent decree, and I really join in appreciating all of the people who worked on this from the beginning until now. You have made an enormous contribution not only to our society as it now exists, but to the future. To my granddaughter Lydia, who will drink this water for years to come, and everybody else's children and grandchildren. So thank you all very, very much. And although we've had some disagreement among people who have really the same goal to protect the aquifer, I hope that everybody will join ranks now and move forward together to to make the protections of the aquifer even stronger.
Would the clerk please call the roll?
Mr. Ammons?
Yes.
Mr. Brown?
Yes.
Mr. Jacobson?
Yes.
Mr. Madigan?
Yes.
Ms. Marlin?
Yes.
Mr. Roberts?
Yes.
Mr. Smythe?
Yes.
Thank you very much.
Thank you.
That motion carried, by the way, unanimously.
Thanks, folks.
Thank you.
Okay, next is reports of standing committees, which would be, I believe, Diane, correct?
Yes. On behalf of the Committee of the Whole, I move resolution number 2015-09-048R, which is a resolution authorizing the entry into and execution of an agreement between the City of Urbana, Illinois, and the Community Foundation of East Central Illinois for Urbana Public Television.
I'll second.
Okay, motion by Marlin, seconded by Roberts. Any discussion? Would the clerk please call the roll?
Mr.
Yes.
Ammons? Mr. Brown?
Yes.
Mr. Jacobson?
Yes.
Mr. Madigan?
Yes.
Ms. Marlin?
Yes.
Mr. Roberts?
Yes.
Mr. Smythe?
Yes.
That motion carries.
On behalf of the Committee of the Whole, I move approval of ordinance number 2015-07-084, an ordinance amending the zoning ordinance of the City of Urbana, Illinois, which is an omnibus text amendment, plan case number 2254T15.
Second.
Motion by Marlin, seconded by Ammons. Any discussion? Charlie?
So I think we need to make sure we know exactly what language we've included on the sign stuff, and I see Kevin sitting down there, so I'd like to find out what he's got to answer our questions from last week.
Yeah, so I have a brief report just on some follow-up questions. I believe you all received memos on this. So these are just questions pertaining to electronic signs. So the first, I think the big question and the changes that we're proposing are to how we measure the brightness of electronic signs. So our current zoning ordinance provides us with a table that you can see on page 2 of your memo. And there are a few reasons that this table is not probably the best way for us to measure and regulate our signs. I think the biggest thing is that it doesn't really adequately address the current sizes of electronic signs in Urbana. As I pointed out last week, the largest sign we have, the largest digital sign we have, is only 33 feet 4 inches. And the way that the table works, without getting into all the math, is that it really allows for smaller signs to be a lot brighter than larger signs, which I don't believe was the initial intent of how we wrote the ordinance. So in our studies, first we had initially proposed amending this table to address the smaller sign issue, but then looking back on some of the materials we have, we found a pretty simple equation that you can see on page 2 of your memo that is provided in a report that was derived from the same source that we used back when we originally drafted this part of the ordinance. And we believe that using this equation would really be an easier way to regulate electronic signs and would ensure that all signs are subject to the standards of brightness that we initially, that was the initial intent of the zoning ordinance. One of the other questions that council had was they wanted us to do an existing conditions survey, and the table that I believe was just passed out to you shows the results of those surveys. I apologize for not putting a title on this, but basically I went out, initially I did a test with Councilman Smythe at the Phillips Rec Center, so we just wanted to test the methodology, make sure that it actually made sense before going out and surveying everything else. I had my father's in town from Mexico, and I decided to have him come out with me last night and help me measure signs. I thought it would be a good bonding experience. So we did that from about 10 till a little past midnight. So for the most part, the signs, we measured, just for the sake of time, we were measuring at the proposed distances that we came up with based on that equation that I referenced. And so you see all the foot candle measurements that we made, first with the sign on, then with my father holding up something to block the sign, which was the methodology that Councilman Smythe and I tested out and found it to be adequate. And then you'll see the change in foot candles for each sign. And we did that for both sides of the signs. All but one sign were two-sided. The exception to that is at the high school. There's only a one-sided sign. So I think the results show that there are only a couple signs that are really quite a bit brighter currently than the regulations we're proposing. And I can say anecdotally, while walking up to those signs, you got the impression that these were really bright signs. So when we did the measurements, that was borne out. I will point out one of those signs is on the top of the list. The top 3 signs on the list are what we would grandfather in, so they wouldn't actually be subject to our new regulations, but we could always ask for that top sign to tone down the brightness a little bit. If you have any questions about anything else on that table, I'd be more than happy to answer them. I think one thing I found as a bonus is that some of the signs, if we were to measure them at 100 feet away, we'd be standing, for instance, in the middle of University Avenue, measuring sign brightness, and just for safety's sake, it would be nicer to not have to go out into the middle of roads like that. I created some maps of that if anybody's interested in seeing them, but I won't show those unless we want to take a look at those. I think the final questions were regarding the actual brightness of the signs, so the foot candle measurements. We're not proposing any changes to the foot candle measurements right now. The changes that we're proposing will really have a large impact or a large effect on what brightness would be allowed as is. So at this point, we're just recommending keeping with the 0.3 foot candles as a maximum brightness at the measured distance. So that is our recommendation. So that really concludes my report. As I said, I can answer questions. So you can approve the proposed changes. You can approve with your own changes or deny them. We would recommend approval. Thank you.
Any questions? Diana and then Dennis.
Just so I understand, so the businesses listed below the line there, the ones in gray what's the practical impact of us passing this?
So the practical is the stuff that's highlighted in gray, that's above the 0.3 foot candle measurement. So I think a couple of those may have, I think a couple of those might require further study and maybe work with the sign owners to actually turn the sign off as opposed to trying to block it. And that's because some of the signs, like at Heartland Bank, for instance, you see that was a little above our regulation on one side of it. But that sign is really pretty small, and it's part of a much larger sign that has that's a backlit sign itself. So it's already putting off the bigger backlit sign. I think is putting off a lot more light than the digital part of that. So I think we'd want to look at that a little bit more. And then, I think for practical, the practical application of this is that, for instance, the Pawn King was really bright, and bears out with the numbers as well as what we, what we saw while we were walking up to it. So we would ask them to turn that sign down because it is quite bright. I think the Wendy's would probably require more study. I think some of the larger street lights around there may have been affecting our measurements, because depending on the way that you hold the meter, if you just turn it slightly one way or the other, if there's really bright lights, it can affect the measurements. But I think that there would be a couple of businesses we'd want to talk to and do some further study.
Okay, go ahead.
Just a quick one. That formula that's included in here, it's the measurement distance equals the square root of the area, and then there's an asterisk and 100. What does that asterisk stand for?
That is just a multiplication.
Multiplication.
Yeah.
Times. Okay. Thank you.
Dennis and then Bill.
Yeah. So, yes, I'm not surprised that there are a couple of businesses whose lights are brighter than what I guess what we have already established as a standard, 0.03. So you're mentioning that you'd like to talk to them. Could you say that you will talk to them and will request that they turn these things down to apply to the standard?
Well, certainly, but I think that
sounded a little bit wishy-washy.
Under our current regulations, I don't know that. Actually, I'd be pretty. I'd guess that they would meet our current regulations. So I can't talk to them until we had some new regulations on the books. But I would certainly do that if those, if these proposals are adopted, and then those are our current regulations.
Earlier, the question came up whether we should be adopting 0.3 or 0.25 or 6 or whatever it was.
Yeah, 0.3 or 0.25.
So why did we drop the 2.5? What's the invalidity of wanting to have a little more control over brightness?
Well, I think for one, there is debate. There are studies that will tell you something lower. There are studies that will tell you something higher is acceptable. This 0.3 is what we have on the books. It was based on a pretty well-cited study back in 2008 or 2009. And I think, from my experience, our current regulations haven't created too many nuisance complaints or any complaints that I know of. So I think just staying with the 0.3 but changing the measuring distance will have a pretty big effect, especially for the smaller signs.
And those measurements that aren't grayed out, but say the second one at the Pines, we have a 0.027. That means that they're just a little bit under the current illumination standards. Is that correct? That's the illumination standards that you can measure?
Well, that would be just under what we're proposing. But if we were actually measuring that at 100 feet away, that number would most likely be a lot smaller of a difference. Or of a, yeah.
Okay.
Bill?
Yeah, thanks for doing this. I had a couple questions about when you measured it. Did you just measure what was up there at the time? Because I think our ordinances I've seen, I'm not sure about our ordinance, says that you should measure it at full brightness with all white showing. Were you able to accomplish that, or?
No, that would require coordination with each of the sign owners, but we did measure at the brightest, when the brightest part of their cycle was happening. So, for instance, at the middle school and the high school, most of what they were putting up was under, but then when they'd flash up the logo of the tiger or whatever, it would be really bright comparatively compared to the other stuff.
As you were going through these, did you notice any that were out of compliance in any other way as far as how fast they were cycling or animating?
I have made note to contact a couple of sign owners regarding that, so yes.
Okay.
Or there's suspicion. I didn't use a stopwatch or anything.
I think just in general, for compliance, we usually do this on a complaint basis. I mean, you don't go out on a regular basis and measure people's signs. If you get a complaint, you'll go out. And I think by having this definition with these formulas, it should give you a better tool to enforce that. Is that your kind of feeling from doing this?
I think so, because as I pointed out a few times, is that the current regulation is basically to measure every sign at 100 feet, and as you know how light works over distance, by the time you're at 100 feet, especially for smaller signs, it's going to be diminished significantly, the amount of light. So.
Okay, thanks.
Mike Madigan.
So help me out here a little bit. You mentioned earlier that you did have maybe a problem measuring one or two of these based upon other light sources that are near.
Well, yeah. Do you want me to elaborate?
Sure.
Or, okay. Yes, like especially at the Wendy's sign, there are a lot of, it's right on Cunningham, and there's a lot of overhead street lights. And the way that the meter works is it basically takes in light from all the surrounding area, the ambient light. But if you have it aimed slightly more towards a source of that light, I noticed when we were taking measurements that it could really make the meter sway one way or the other. And we tried to be consistent and not let things affect it. But when I saw those measurements, I was just thinking that the way it looked to me without using the meter was that sign was not bright at all. So while it's a somewhat exact, while it's exact measurements in some ways, I think there's some question about some of it. So.
So that could be the case with Walgreens then, which is right across the street from Wendy's.
It could be, but that one was very, very bright. But you're right that could have been affecting it somewhat.
Well, I just noticed that. So in maybe I'm just not reading there's not a key to this document.
Right.
So your second to last column indicates blocked, and it's 1.1 at Walgreens.
Yeah.
But then the final column shows, I guess, when you were actually measuring the sign unblocked.
Oh no, sorry. The third to last column, and I apologize. I threw this together somewhat quickly. The one that says SE on is measuring it with it unblocked.
So SE delta is the difference?
Yeah.
All right.
That's correct.
Okay. So currently we're doing this on a complaint basis. Is that right?
Yes.
Do you get a lot of complaints?
I haven't received any. I've only been here a year and a few months, so.
Okay.
Yeah.
Well, in a year and a few months, we've had no complaints. So while I appreciate your work on this, I'll be opposed because I just think this is another case of the government regulating something that doesn't need any further regulation.
Okay, we have a motion by Marlin, seconded by Ammons. Any further discussion? Would the clerk please? Yes, Diane?
I'd like to amend the motion to change the formula so that it shows as a multiplication sign and not an asterisk, so it's perfectly clear to somebody trying to read this formula what is meant by it.
I'll second that. Why not? Clarity is perfect.
That's what's used in the computers, right? The asterisk?
Yeah, and in algebra and such. So,
Okay.
because in X.
When did it?
We could have language translation for
Okay, I guess
multiplication.
I'm old algebra then.
Okay, so is that going to create a problem?
Not really, but algebraically you generally solve for X, so you don't want to stick an X in the middle, which I think is why you use.
Okay, never mind. All right.
All right, now we're going back to the original
withdraw also.
motion. All right, Aaron.
So let's borrow from Mike Madigan. this Mike Madigan. Exactly, help me out here. So how does this affect billboards?
This has no effect on billboards right now.
Okay.
We don't have an ordinance.
All right, thank you.
Charlie?
What it does affect, to me, is a level of consistency and accurate measurement. You know, what we have now is wrong, and this fixes that. And so, and it also potentially, and as well, if there are the 5 votes for digital billboards, it makes a level, it provides a level of consistency, and we won't have to go back and revisit this. Because I think if you do decide to do digital billboards, the 2 standards need to be the same.
Oh, Eric.
I just want to state for the record that I do believe that some degree of regulation is necessary because of the effect of bright lights on abilities of drivers to actually see the road. And so we should have standards that are well below the level of brightness that, and people may not, people may not complain about that, about having their vision somewhat impaired by photo bleaching from bright signs, but it's a phenomenon nevertheless, and so I will support the need for the regulation explicitly, and this item before us in particular.
Okay, would the clerk please call the roll?
Mr. Ammons?
Yes.
Mr. Brown?
Yes.
Mr. Jacobson?
Yes.
Mr. Madigan?
No.
Ms. Marlin?
Yes.
Mr. Roberts?
Yes.
Mr. Smythe?
Yes.
That motion carries.
Thank you.
Diane?
Ordinance, would you need to recuse yourself on this one? Okay. Ordinance number 2015-09-099, an ordinance amending the zoning ordinance of the City of Urbana, Illinois, revising Article 2 and Article 5 to establish definitions and use provisions for microbrewery, the plan case number 2254T15.
Second?
Okay, motion by Marlin, seconded by Smythe. Mr. Madigan?
Madam Mayor, it is with deep regret that I must recuse myself from this ordinance, which is going to allow a very exciting business in my ward.
Okay. Any other comments or questions? Okay, so who seconded this one?
I did.
Charlie did, okay. We have a motion by Marlin, seconded by Smythe.
And I'll agree with Mr. Madigan. It's exciting.
For the record, Mr. Smythe agrees with Mr. Madigan. Would the clerk please call the roll?
Mr. Ammons?
Yes.
Mr. Brown?
Yes.
Mr. Jacobson?
Yes.
Ms. Marlin?
Yes.
Mr. Roberts?
Yes.
Mr. Smythe?
Yes.
That motion carries.
For the committee, I move approval of resolution number 2015-09-049R, resolution approving property tax rebates for certain properties within the Behringer Commons subdivision.
I'll second that.
Motion by Marlin, seconded by Jacobson. Any discussion? Would the clerk please call the roll?
Mr. Ammons?
Yes.
Mr. Brown?
Yes.
Mr. Jacobson?
Yes.
Mr. Madigan?
Yes.
Ms. Marlin?
Yes.
Mr. Roberts?
Yes.
Mr. Smythe?
Yes.
Mayor Pressing?
Yes.
You vote on this one, yes.
That motion carries. Okay, reports of special committees. Reports of officers. I think Libby Tyler, Community Development, is coming up.
Good evening. There is an upcoming dedication of 2 new Habitat for Humanity homes in Urbana. This will be happening this Thursday, September 24th at 6 p.m. If it's raining, I believe the dedication will happen at the Restore. And this will be at 301 and 303 Thompson in Urbana. And this is a real pleasure to see these 2 new homes, not just for the residents who will be there and providing affordable housing, but it wasn't that long ago that this was one of our problem properties that we were tearing our hair out about and trying to figure out how to address a property that had been pretty well abandoned and was a blight on the neighborhood, and this is a great turnaround. So I wanted to bring that to your attention.
6 p.m. on Thursday, is that what you said?
Yes.
Okay.
September 24th, 6 p.m., 301 and 303 Thompson in Urbana, North Urbana.
Any other reports of officers? Bill Gray. Public Works Director, extraordinaire.
3 quick items. I just wanted to report on Wednesday, September 9th, we had a very successful Light the Night bike light distribution. That evening, there were 900 bike lights that were installed on bicycles. One location was at Illinois and Lincoln. The second was at Wright and Green. There's about 15 workers at both sites, and this has been a very successful program, again, for bicycles to ride at night to be legal with the lights fixed in the front and back. Number 2, the Illinois chapter of the American Planning Association has awarded the city of Urbana for a sustainability award for its Urbana Sustainable Water Management Plan. We'll be receiving this award in person soon, and this is kudos for certainly Scott Tess and the Sustainable Advisory Commission and others helping to put this together under the mayor's leadership. So I wanted to announce that. And last but not least is leaves will be falling soon, in about a month from now. October 19th, we will start our free leaf collection program at the curbside. There will be 4 collections this fall. Again, they occur on your regular U-cycle day. October 19th is the first. November 2nd is the second week of collection. November 16th is the third week of collection. And lastly, November 30th will be the 4th collection week. So I wanted to alert you. We will put signs out strategically to inform the public and other means too on our website, et cetera. So get ready, get those rakes ready.
Aaron?
Mr. Gray. Sorry, I just can't let you go that fast. I wasn't able to get any lights on my bike, so I wonder if you had a few extra that I could get. But seriously, I was wondering, where do we get the bike lights from? Who pays for those? How do we take care of that?
Good question. Actually, 4 agencies all contribute to fund that. We, the university, City of Champaign, and MTD. We do have some lights left over. I think I could make that work for you.
I don't want any special treatment.
No.
I was just,
No.
Okay. Also, I was out with my mother and my wife and children and nephew, grandson. I'm just giving up my age here a little bit. But we were at Meadowbrook Park, and there was an accident there. There was a lady leaving on, I think that's Vine Street, right? And she was headed north. And I don't know if she was blinded by the western sunlight or something like that. I'm wondering if there's something else that we can do right there to help safety and prevent any further concerns, especially in the later evenings, because I don't know, when I talked to her, I was right there on the scene, and she said that she looked both ways, she just didn't see this vehicle, and it could have been a pretty bad accident, actually. So just wondering if we can do something else to help about that intersection there, to help people. And as far as the ash trees that we are cutting down, what are we doing with the wood?
It's going to LRC, or it's chipped. The smaller limbs are chipped, and LRC, I think, has to strip the bark. I don't know. It's a good. I should pass that question on to our city arborist to look into that. But we don't want the logs and the wood removed from Urbana or from the county at all, because that bark beetle, Emerald ash borer, I should say, is in there. But the LRC properly disposes and handles that material once it gets out there. But the actual process, I would need to ask them to get back to you with that, so I will.
Okay, thank you.
Eric?
So just a modest request, because of how people are blinded by the setting sun and rising sun. Do you think we could reorient all the streets so they go northwest to southeast and northeast to southwest?
Think big.
Well, you could take a little while to think about
Yeah, I
that.
could think about
Well,
that.
then the problem would simply happen at a different time of the year. Right now, the sun comes out, comes up directly from the east and sets directly to the west. It's actually a very dangerous time for bicyclists too, because we're not seen for exactly those same reasons. And there's not a lot you can do except to be aware of the issue and double check everything, because if you were to do the northwest southeast, you'd just change the time frame. It'd be winter or
Okay. All right. Moving right along. Do we have any other officers' reports?
Do I qualify as an officer?
Sure. Aaron?
I just wanted to say that I enjoyed my trip to the IML, and I did see Diane there and Mike and the mayor. It was beneficial for me and Libby. Exactly, that's right. It was beneficial for me. I did learn a lot. It was a little conservative for my taste, but I did enjoy Chris Kennedy's speech that morning, though. It was enlightening and inspirational, I might say. I just wanted to say that there was quite a bit that I learned there. It was nice to talk to a lot of other village trustees and representatives of different cities, and to spend some time touching base with them. And I look forward to calling some of them up, talking to them, and seeing what other things that they have done in their cities that we might be able to do here. So I just wanted to say that it was something beneficial, and I don't have a detailed report, but it was good for me.
Anyone else? Eric?
Oh, I really regret not having been able to go to the Municipal League, but my explanation is that I was in Washington, D.C., being part of an effort to lobby Congress to increase funding for the National Institutes of Health. So perhaps this will bear some fruit for all of us, and especially research funding for the university.
Okay. New business. We have emergency solution grants. We've got 3 of them. A is resolution number 2015-09-050R. And to explain this, we have...
Hi everyone. I just wanted to explain that I'll be presenting on all 3 of these resolutions at once. If I recall correctly, when the agreements themselves were passed, they had to be voted on individually, but I'm just going to present on all of them to start it off. So these are amendments to emergency solutions grant agreements that were originally passed by Council on August 17th. And as noted in the memo and in the resolutions, the Illinois Department of Human Services sent a notice of outstanding application requirements on August 31st to the city. And as some of the outstanding requirements required additional agreements or additional statements that subrecipients had to agree to, and in consultation with the legal division, we determined that it was best to bring these agreements back to council with a formal amendment and put the material that DHS requested into these agreements formally. The only material being amended to the agreements is the attachment C, which was included in the packet. It contains a number of questions that the subrecipient agency will have to answer, provide some statistics, and it also has a few statements on there that the agency has to agree to. And once they provide those statistics, sign and agree to the statements on the attachment, then that will satisfy the part of the requests that DHS has made that relate to the agreements themselves. As you saw earlier, I passed out some corrections to 2 of the resolutions, the ones with Crisis Nursery and the Salvation Army. That was to correct a clerical error in section 1 on page 2 in the first sentence for those two agreements, there was a phrase that was missing that was inserted into the document. So that was just the explanation for the correction for those resolutions. So are there any questions?
No questions. Okay, is there a motion on the first resolution?
I'll make a motion that we adopt Resolution 2015-09-050R, a resolution approving an amendment to an Emergency Solutions Grants Program subrecipient agreement with Community Elements.
Second.
Motion by Roberts, seconded by Ammons. Any discussion? Would the clerk please call the roll?
Mr. Ammons?
Yes.
Mr. Brown?
Yes.
Mr. Jacobson?
Yes.
Mr. Madigan?
Yes.
Ms. Marlin?
Yes.
Mr. Roberts?
Yes.
Mr. Smythe?
Yes.
That motion carries. Then we have resolution number 2015-09-051R, which is for Crisis Nursery.
So moved.
Second.
Motion by Smythe, seconded by Jacobson. Any discussion? Would the clerk please call the roll?
Mr. Ammons?
Yes.
Mr. Brown?
Yes.
Mr. Jacobson?
Yes.
Mr. Madigan?
Yes.
Ms. Marlin?
Yes.
Mr. Roberts?
Yes.
Mr. Smythe?
Yes.
That motion carries. Resolution number 2015-09-052R, which is for the Salvation Army.
I'll move.
Second.
Okay, was that Dennis?
Yeah, it was.
Dennis Roberts, and seconded by Diane Marlin. Any discussion? Would the clerk please call the roll?
Mr. Ammons?
Yes.
Mr. Brown?
Yes.
Mr. Jacobson?
Yes.
Mr. Madigan?
Oh, sorry, yes.
Ms. Marlin?
Yes.
Mr. Roberts?
Yes.
Mr. Smythe?
Yes.
That motion carries. Okay, thank you. Now we have ordinance number 2015-09-100, an ordinance amending the 2005 Comprehensive Plan of the City of Urbana, and this is adoption of the Champaign County Multi-Jurisdictional Natural Hazard Mitigation Plan. Update as an amendment to the comprehensive plan.
Yes, thank you, Mayor.
Okay.
This is a 5-year update to the hazard mitigation plan. I should note the word natural is no longer in the title, as we now deal with man-made disasters. Those were added with this update. And this is a relatively minor update. There's a lot of new demographics and information, statistics about how many buildings there are in the city within floodplains, things like that. And there were a few tweaks to the goals and objectives, but generally they stay the same. It's a pretty minor amendment. So the hazard mitigation plan, it's FEMA defines hazard mitigation as a sustained action to reduce or eliminate long-term risk to human life or from property hazards. This is generally in opposition to an emergency response plan. So a hazard mitigation plan is items we can work on to make hazards less impactful. Things like trimming trees before a storm, educating residents about where tornado shelters are, requiring a higher level of wind resistance in our building code, things like that. So it's an overall framework for the county, and it identifies actions for specific jurisdictions, such as the city. So there are several comprehensive plan goals which support the adoption or the readoption of this plan as updated, mostly dealing with floodplain and disasters, having dependable utilities, things like that. Quick history. In the year 2000, there was the Disaster Mitigation Act at the federal level, which required that jurisdictions have a hazard mitigation plan if they wanted to receive funding for mitigation grants. With the city, we adopted our own hazard mitigation plan in the year 2005. And then the county received a grant to do a countywide grant In 2007, that plan was adopted a couple years after that, and now we're on the 5-year update of the plan. The planning team, there were 27 jurisdictions. 9 of them were larger cities or entities like the U of I Police Department and the various cities. We've been working on this plan for about a year. RPC is spearheading the effort. So the document has a few updates. Just to run through it really quick, the first chapter is an introduction, talks about the processes. The second chapter talks about the plan area, communities and capabilities. So population, land use, how many structures are vulnerable to different disasters, things like that. The next section deals with hazard and risk assessments. So the natural hazards are the same as the 2009 plan, severe storms, tornadoes, severe winter storms, floods, extreme heat, drought, and earthquake. For the 2015 update, we've added a couple technical hazards or man-made hazards. So that includes hazardous materials transport and storage, and active shooter scenario for the campus. The goals, there are some changes on the language of the overall goals, but it's basically the same things, just minimizing avoidable injuries and deaths, reducing potential losses to property, improving the capability of the populations to recover, and encouraging interagency cooperation on hazard response. We also retain our National Flood Insurance Program compliance with the plan, and the plan is to update the plan every 5 years. So there are a few completed actions that were removed from the plan from Urbana's list, providing a backup maintenance stormwater detention basin in the subdivision ordinance that's been adopted, requiring a 1-foot freeboard for construction above the 100-year floodplain is adopted, and updating the FEMA maps. We just did that a couple years ago. And there are a couple added actions which are really just related to continuing those things that we recently adopted. Other than that, there were a few other updates to just for demographic reasons, and bringing in census data and updating other data. The Plan Commission voted 4-1 to recommend approval for the City Council to approve the plan and to adopt it as an element of the comprehensive plan.
Okay, thank you. Any questions for Jeff? Bill?
So I saw somewhere, I think maybe on the RPC website, that the Hazard Mitigation Grant Program requires that we have a flood mitigation plan. Is this actually a flood mitigation plan as well as a all hazards plan? I mean, does this meet that requirement?
I'm not sure if that's a separate plan. Do you know, Brad?
I know it to be a rated community when campaign is. I think they actually monitor and track.
Brad Bennett, Assistant City Engineer. What we have adopted here at the city is we have a flood hazard ordinance. It sets some requirements, and it's based on the state model, so it really isn't a mitigation plan. There is a community rating system program that you can voluntarily participate in, and as a result of that, you can actually get your insurance premiums lowered. But we don't participate in that, and I think that might be what the reference to the flood mitigation plan is, where they actually track some statistics as far as how many properties that you have flooding, what the amount of damage it is, and you look at that historically over time and obviously try to reduce that.
So, do you know if we've applied for or received any hazard mitigation grant program funds that go to purchase properties in the floodplain, things like that?
So for that specific use, purchasing properties in a floodplain, we had done a pre-application, and we were told that the properties we were trying to purchase weren't of a high enough danger level that grant would succeed. I believe we have had some other hazard mitigation grants for things like backup generators, and that's something we'll apply for more of those.
Okay, thanks.
Diane?
The first item on the list there is complete installation of emergency backup power systems for remaining essential city facilities, such as fire stations 2 and 3 in the Civic Center. Are there other essential city facilities that have no backup power systems, or are those it?
I believe it's just those. I'm not sure if it's for an upgrade, or maybe Chief Neitlinger would know the status of those.
And we have backup power at the station here at the city building. We have backup power at the campus station, but as far as the south station goes and the north station, there's no backup power. The apparatus in those stations have generators on the apparatus, but to date, we haven't been able to get generators to power those stations.
How much would that cost?
I would say probably in the range, to get an appropriate generator, about $10,000 per station.
Okay, and then I had one more question.
Go
Thank
ahead.
you.
What's your other question?
About, let's see, the one requiring developers to pre-approve a tax benefit district and to, I assume it's to take care of a detention basin if homeowners association falls through. Is that a new item?
Yeah, that's something that we've included for about the last 5 years, and actually that has been changed to a certain extent with the adoption of the stormwater utility fee.
That's
What they do presently now is if the city has to come in and do some maintenance or reconstruction of a detention facility, they actually charge that against the stormwater utility fee that's assessed that property. So, you know, they'll actually include it as part of the stormwater utility fee, any costs for the city having to do any maintenance or work on a.
So we no longer have a tax benefit.
Yeah, if you look at the
District.
recent, and I don't know if Jim wants to weigh in on this, but I know the last several stormwater detention basin maintenance agreements, we haven't had the special service area requirement written into it. If it's a subdivision, the homeowners association is responsible for maintaining the detention basin, but the tool, if they're not maintaining it, is right now is the city can come in and cause whatever work needs to be done, and they actually charge it as part of the stormwater utility fee against those properties that are tributary to the basin.
Okay, thank you.
Okay. Any other questions for Jeff? Is there a motion?
Move approval of ordinance 2015-9100, ordinance amending the 2005 comprehensive plan of the city of Urbana, Illinois, adoption of the Champaign County multi-jurisdictional natural hazard mitigation plan updated as an amendment to the comprehensive plan, plan case 2264 CP15.
I'll second that.
We don't use the word natural in the title, though?
That was stricken from the actual ordinance.
Okay. Okay, motion by Smythe, seconded by Jacobson. Any other discussion? Would the clerk please call the roll?
Mr. Ammons?
Yes.
Mr. Brown?
Yes.
Mr. Jacobson?
Yes.
Mr. Madigan?
Yes.
Ms. Marlin? Mr. Roberts?
Yes.
Mr. Smythe?
Yes.
That motion carries. Next, mayoral reappointments. I have 2 people for the Urbana Public Television Commission for terms to expire June 30th, 2018, Andrew Wadsworth and Peter Folk, and they've all They're already on the commission.
Move approval.
Second.
Motion by Marlin, seconded by Jacobson. Any discussion? All those in favor, please signify by saying aye.
Aye.
Those opposed? That motion carries. Okay, we are down to discussion of the Boneyard Creek. Did you want to, we have, Libby's going to talk about what we have now, and Dennis wants to talk about what we might be doing in the future. Would you like to summarize what we're doing now, Libby?
Yes, thank you. This is a section in our zoning ordinance that I've actually copied you the majority of the section, and might help to even look on page 4, item G. Talks a little bit about the process. There's been some confusion in recent months about how we process permits, development permits in our Boneyard Creek district. And you'll recall not too long ago we did redraw the district. It's on the zoning map. So this is actually what we call an overlay district in zoning. And what that means is you're still, say you have property that's zoned R2, it's a single family home. So in addition to the regulations in R2, you also are subject to the regulations in the Boneyard Creek district. So the district includes the remapped floodplain plus any properties that touch on it. And the provisions of the Boneyard Creek District zone are very broad. So even to, well, today we processed a dilapidated garage was falling down. Even that needed a permit. And the reason was, the reason is that, you know, there is a concern about flood hazard along the creek, number one. Number two, if you own property and you have flood zone or floodway, which is more prone to flooding, then you're going to have some limitations. And in our zoning ordinance, we actually offer some trade-offs for folks who own those properties to encourage them to pull away from the creek and to help to protect the creek. The district is also there to help us promote 2 plans. We have 2 master plans that cover our stretch of the Boneyard. One was done back in 1978. I've got a copy I'll show you. It's an older plan with kind of hard to reproduce black and white drawings, and you know, talked about some of the vision that was in place back in that era. But then as we get into the downtown, this plan takes over, and I know that you're more familiar with this master plan. So we have 2 plans. Now on to the administration of permits for people who are within the district, the zoning district. Before this was all established, once upon a time, there was actually an entity called the Boneyard Creek Commission. And that Boneyard Creek Commission included not just the city of Urbana, but City of Champaign, University of Illinois, and that was a group that helped us come up with this plan. And that was a group that really laid the groundwork for a lot of the wonderful improvements that have occurred along the creek. If you think back many years ago, it used to flood on Green Street, and there were no improved sections of the Boneyard. It was all just kind of this urban wasteland. It was a lost opportunity. And so I think that you can see now, because of these planning efforts and this interjurisdictional effort, we have improved areas of the Boneyard in Champaign, on campus, and now in Urbana. So that's a little bit of the background. We do not have a Boneyard Creek Commission now in Urbana. We do have a Boneyard Creek Commissioner, and that commissioner is appointed by the mayor with the consent of the council. We've been fortunate enough to have Professor Clark Bullard as our commissioner for the last several years. And his role is defined in the zoning ordinance, and it's to advise the city on matters that pertain to the Boneyard Creek, and also to help advise the staff as we administer permits in the creek. Now, looking at this section G, and it's a long section. It talks about transfer development rights and all this very detailed zoning regulations that are meant to encourage the good things to happen on the Boneyard, to help make it a little easier for people who own property in the Boneyard to maybe get some benefits for being there, and to allow them to develop in a way that's safe and doesn't create more flooding. So you'll see here that we asked for a conference for people who want to build really anything or demolish anything in the Boneyard Creek. We asked for a conference. We asked for an application. There's an application fee. It's $150. And then the zoning administrator, in many cases, can issue a permit, but not all cases. And what the zoning administrator, who's myself, appointed by the city, does in reviewing this is that person confers with our city engineer, Bill Gray, and with the Boneyard Creek Commissioner. So we meet as staff. So there is no such thing as a review board or commission or committee. It's a staff process. We do not make final decisions in a sense that as we review these permits, as long as the modifications are such as are set here, and those only pertain to some reductions in setback, again, if you pull away from the creek, and some increase in height, again, to protect the creek, that we are allowed to then send, and we agree that it meets the criteria set out in the zoning ordinance, so we do review that, and we review adherence to the plans. We can then send to the Plan Commission a notice of intent to issue. So we don't issue on our own. So the staff sends to the Plan Commission a notice to issue a permit. And there's a 10-day period by which the Plan Commission or other persons may say, hey, we want to hear more about that. You know, bring that to the next Plan Commission. So it's like this whole thing about government. There's certain things that Plan Commission sees and then the council sees it. There's certain decisions a zoning board might see, and maybe they can vote on a minor variance, but you're going to see the major variances. It's a balance, it's a structure, so we get lots of different eyes. And the Plan Commission will hear the case if there's an appeal of that notice. The Plan Commission will also hear the case, alternatively, if there's any request of a petitioner that exceeds these small allowances that are in the zoning ordinance. And the Plan Commission does issue the final permit. So that is why City Council does not see the permits now. They do tend to be small things in the Boneyard. And if they want more, then it may become a major variance, and you may see it like with the Central Illinois Mosque case, for example. So we do have a process that involves staff, Boneyard Creek Commissioner, the Plan Commissioner, and Plan Commission and City Council. And it is complicated. We do work hard to bring folks through it. In the staff meetings, we'll have our building safety people there. We'll have Brad Bennett and other staff who are knowledgeable about drainage. So that's how the system works now. I know that there's some ideas to be presented this evening, and I would just say that we did have another situation, a case where we had a similar staff committee that reviewed permits, proposals in the mixed office residential zone along Green and Elm Street. And once upon a time, that was actually was a committee that included staff and as well as other folks who would help us. And then those could be appealed to the Plan Commission or were brought to the Plan Commission for larger types of projects. And we changed that so that most of those now go to the Plan Commission, but anything that's an adaptive reuse in the MOR zone, which the city thought was a positive, or that had very minor changes, could still be done administratively. Now, why would you want anything to be done administratively? Because we issue thousands of permits every year. It's a way to get things, small things moving. It's not something that you want to clog up Plan Commission, and you want to use these processes to encourage the things that the city wants and to maybe take a closer look at the things that the city might have more questions about. So that's the best best I can do in just an off-the-cuff description, and it really is not, in the description that was presented tonight it's very different than what that says, and any changes must go to the Plan Commission as a text amendment to the zoning. We're talking about people's property rights. We want to make sure that we're compliant with those property rights and compliant with our plans. So if there is some direction to go back and ask for a text amendment change to the Plan Commission, we can certainly take that up as a review and a study, and would want to present something that meets broad goals that the council might lay out. So it's not something that council could just pass an ordinance saying something. It has to go through that zoning procedure.
Okay. Dennis?
Yeah, since this was a discussion that Charlie and I asked for, I appreciate the chance to get second wind on it. And I think that that I personally do have very little that I find to be a problem in pursuing the appropriate steps in the Boneyard Creek process concerning the Boneyard Creek District to achieve the appropriate zoning decisions which all of us support and understand and are clearly defined within the parameters of the zoning ordinance concerning the Boneyard Creek. I think my most significant problem with the current process is really one of transparency. And I say this because, of course, recently the City Council had a walk through the Boneyard Creek. We talked with Mr. Fosty. Clark Bullard was there with us, and we made a walk through. We looked at different potential ways of seeing the creek, of maybe thinking about how to support its development and choosing certain directions for those developments. And on the other hand, we have the rights of the property owners who are along the creek who wish to erect whatever it is that they want to do with their property, which is their legal right. So I don't have any issue with the people pursuing their property rights in a clear, open, and understood manner so that not only the administrators in the creek area have a chance to review it, but that the entire community benefits by understanding how the nature, how the environment, and how development along the creek is changing in our community. And it is more distressing to find out that that information when you see the erection of the first story of a building that you had no clue was going to be erected. So, I have 3 points that I want to talk about concerning decisions and the process of understanding how we appreciate and support and protect the creek area. The first is that I feel that there's a need for greater transparency and perhaps even public participation in those meetings that are now conducted in conference rooms behind closed doors, which are not noticed to the public, which are actually not noticed to the city council members, and where preliminary drawings and blueprints and ground plans are discussed in careful detail by the administrative board, which of course includes some staff members and engineers, members of public works, and also community development, but at which there is no attempt to notify other members, other individuals who are, say, within, like, I don't know, 500 yards of the development, the city council members themselves, or the general public. There's not an opportunity for public input. These meetings are not noticed to anybody. They don't appear on the city website. And yet, very significant preliminary decisions are being made about future development along the creek bed. So my question that I want to bring to the city council members is, isn't it more important that we have some transparency at an early stage rather than at the final stage where all the decisions have been made, where we have a chance for the public to become aware? And to receive, even in some way, some discussion, whether they sway the decision or the appropriate decision of the board or maybe the commission as we would envision it in the future. So, so my first question, my first complaint is lack of transparency at a very basic level as development approvals are being made, as environmental issues along the floodplain are being discussed, and where bonus points or other, or what you might call, I'm not even going to talk about the Queequeg permits, because I don't think that's in the City Council's jurisdiction. I think that's being handled pretty much by the perimeters of the floodplain and our zoning laws. But where very basic decisions are being made. So my next point is that I think the public needs to be more involved in the awarding and understanding of what is being offered for bonus points or other developmental variances. During the Administrative Review Board process, these various benefits are awarded to the developer without public input or review. And issuance of Queequeg permits and variances are offered regarding the site plan of the building height, what the allowable building height will be, side yard, backyard, or front yard setback variances, and changes in the parking requirements of the development. So while it is important to protect the creek, we also know that it's not possible to build within the floodplain. So in the sense, the creek is somewhat protected already. So if your property, though, just touches the floodplain, but if your building is situated outside of the floodplain, that's a plus. That doesn't require any creative thinking to think, well, that's the appropriate thing to do. But on the other hand, when you're allowing a building to be taller than any other building next to it, or to extend much farther to the side yards, you're going to be affecting the building next to you, whoever owns it, in a way that they might not even be present to complain about or have to state an opinion about, because they're actually not invited to this meeting. The only people who are invited to this meeting are the developer, his architect, or his lawyer, and city staff. So, although I'm able to walk into it, I hadn't been invited to it, and there's no process for us to know when these are going to take place. So that's my second point. So the third thing I'm suggesting is, why not actually reinstitute the Boneyard Creek Commission as a commission? We would have all the same processes going on, but we would have the addition of having an opportunity for public input, because it would be a commission meeting, and there would be an agenda. It would be pre-noticed in the paper or by the usual ways of noticing. We would have one or two or three individuals of the public who would be involved in the discussion at an early stage, who are qualified people because they would be selected by the mayor. We already have a Boneyard Creek commissioner. He has no commission to lead. He himself only can advise, and although the advice of both the Public Works Director and the commissioner are asked for and registered, it's not a vote in the sense that it actually would change the direction of the decision of the administrator, the zoning administrator. Now, I feel that we all probably are working for the best possible good and for the best possible result at the creek. But why do we keep this in a closet? Why don't we open this up to the typical public review and participation that's offered to all the other decision-making bodies that the city uses. The Traffic Commission oversees the traffic control, parking, street signage, street signal choices, and a member of the City Council is on the Traffic Commission. These are not earth-shaking decisions, but they affect people in neighborhoods. They affect people who park and use the streets on a general basis. And that's considered important enough for public participation. And indeed, I've been on the Traffic Commission for years, and people do come because they have a question about a single stop sign. The Tree Commission, the most probably invisible commission in the city, oversees the maintenance of the city's forest canopy. It advocates for tree preservation. It talks about the problem of the ash borer, the emerald ash borer in the trees, and what might be done for it. It's guided by the knowledge of the arborists, and people who are the professionals that we hire. And yet, any public person can walk into those meetings, and those meetings are posted. The Historic Preservation Commission. It oversees historic properties in town, suggests landmark designations, advocates for historic preservation. It has a purpose, a job to advocate for the cause of historic preservation. So why don't we have then a group or an entity, just like a commission that we have in these other departments and other topics in the town, to advocate for the use, the future development, and the best protection of the creek bed, the Boneyard Creek Commission. Have a few people in the community who want to participate and are appointed by the mayor and have the standing to take that appointment and to participate in some of the discussion and the decision-making along the way. And then give the commission some purpose besides just being a rubber stamp. Give it a role of reviewing proposals, making comments on documents that affect the Boneyard Creek, advocate for the creek as a city amenity, a green space, talk about the extension of the multi-use paths which were envisioned originally in the 1978 Boneyard Creek Master Plan, and then, of course, as modified in certain sections by the update 2008 Master Plan that came from Wank and Associates, which we're working on now, and we're so pleased with the result of the first completed section that was dedicated last year. And then, allow that creek and the commission to establish that any developments that are consistent with the goal of the creek to become a linear park throughout the city. That's one of the city council goals and has been for several years. And then finally, allow the commission to work in a creative way to build partnerships, to seek out state, federal, and local funding, and to explore sources of funding to advance the vision of the creek bed as an amenity to the city. And this would be useful to staff because the staff may not have the time constantly to be working on looking for funding. And but a commission could look for funding, just like the Sustainability Commission gets grants and applies for grants to and even wins awards for its work. So I'm just wanting to have a conversation about transparency, about public participation before variances are allowed or admitted, and to consider creating a creek commission that actually worked like a commission, smelled like a commission, and thought like a commission, and actually assisted the city like a commission would. Again, it's all about public participation in an area of the city that's changing now, because we're seeing the demolition of like 5 to 6 buildings in a consolidated area, and while we can't control the kinds of buildings that might be allowed there, to some extent, at least we can inform or we can make choices about whether they're going to exceed certain limits or if they're going to meet certain limits that the city has allowed. So I think it's a worthwhile thing to talk about. I don't see that there's any problem with it, and I don't see that it countermands the responsibilities of Libby Tyler as the administrator of the zoning authority or anything else. And you have to realize that only if there's a city council member or an elected official disagrees with one of the decisions that are made about the creek and its development and the ground plans and the placement of the parking and whether the allowances for higher or wider building footprints come about. It's only if an elected official disagrees with the judgment, and they have 5 days, I think it is, or maybe it's 10, to make that disagreement. Otherwise, these things are fiat accompli. And how many of us have ever really heard of or tracked the decisions that come out of the Boneyard Creek administrative meetings, which are just staff meetings? I mean, we may get a notice of it and it's an email, but I mean, it's never mentioned in the city council meeting. Attention is never brought to it outwardly. This is all I think a lot of things happen very much under the radar, and I think that as city council, we should try to bring as much to light as we can, and I don't think this hurts, I think this helps. And I'd like to read one comment from the Boneyard Creek Commissioner. He wrote to the mayor on July 6, 2015. As a Boneyard Creek Commissioner, I found it very frustrating to make totally reactive, piecemeal decisions about the ways to preserve the 1978 Boneyard Creek Master Plan's vision of a pedestrian walkway connecting downtown and campus. Basically, I've been forced to approve deviations from zoning requirements in order to use the bonus points mechanism to prevent encroachments on the stream bank that would permanently foreclose the option of building a path in the future. So even the Creekway Commissioner has reservations about the process, and he feels that many times things are just decided, and there's not really a way to direct the decision beyond a certain point. And I just don't think that's appropriate, so that's why I brought this up.
Okay. Eric?
There are a couple of points that Mr. Roberts has made that I totally agree with. I would support the when we have a resolution formed, a creation of a Boneyard Commission. I think the area is special. It's a special feature. I also will support a charge to the commission of planning for a public walkway along the water. I think that I don't think there's any city that has maintained public space on a waterfront that has ever regretted it. And clearly something needs to be done with the area. The reality is so far short of the potential. So it really does warrant a standing commission that meets regularly to begin to implement the master plan. I believe also that we really need a thorough exploration in some way of the hydrological features that are peculiar to the area. On both sides of the creek, I mean, we're really talking now about from downtown out to the Phillips Center, that this is the part that's above ground now, and that is not part of the Boneyard Creek Park. And all along there, the structures that are on both sides of the creek are settling, and they're settling faster on the side toward the creek than away from the creek. So, so we need to really understand what's happening, because I think it's likely that we need some different kind of building code there for new structures. And you know, definitely there's I mean, there are, you know, many of the structures that are there are now abandoned or even when still lived in are decrepit or have just been demolished. So, so I would strongly support the establishment of a commission to deal comprehensively with this particular area and to engage proactively in how this area should be developed.
Charlie?
The reason I'm supporting Dennis in this is much along the lines of what Eric has just said, is that I feel a level of frustration with trying to figure out how to make the Boneyard Creek into something, how to get to the 78, let alone the 2008 plan. I know it's a lot of money, and you know that's one of the issues. We have to figure out how to get the money to do this. But at the same time, the structure that we have right now is sort of piecemeal, and we need to find some happy balance between this section 13.4 and some kind of commission that can provide some public light on the more important aspects of the decisions that are being made today behind closed doors, and at the same time speed up and give us a clear way, maybe it's 20 years, 30 years, 40 years, whatever, to get to our goal of a linear park from one end to the other here. So I think we need to explore how we modify the zoning section now to add some level of transparency to the important decisions, and really develop a roadmap that's not piecemeal, but that actually has a purpose and a goal, and will drive us to get something that may not occur in the lifetime of some of us, but has great potential. One thing that I want to point out is that we had a recent case about 3, 4, 5 years ago, I know, where we tweaked some of the zoning administrators' powers because it was too much. Too much was being done administratively, not enough was being done in the open, and some conflicts developed. And so I think it's important that we periodically fine-tune things like this, you know. And so I look forward to ongoing discussion.
Eric?
I just want to clarify one thing. I am not, in supporting this, I am not in any way critical of the existing Boneyard board, because the individuals on that board are very, very comfortable, have proven themselves to be very comfortable in operating in a very transparent way and with complete accountability to us and to the citizens. I think we just have to provide a framework that creates a process that creates that transparency.
Dennis?
Yes, exactly. You know, I mean, in observing the activities and the discussion of the Boneyard Creek Administrative Body, I found that great discussion takes place. Thoughtful, comments are appreciated and, absorbed. There's room for the criticism that may come from, individuals involved or peripherally involved. And it's all, ultimately, it's a mix of information and exchange that makes the better solution. So what I'm trying to do is just open it up a little bit more so that we can, the community can watch that process. And actually, in every single open meeting, there's a place where there's citizen input. And, sometimes we learn from the citizens. We learn from the citizens who've come to talk to us about the consent decree today and for the last couple of weeks. And we are always learning from our citizens. I haven't really evaluated it, but I did get a copy of the amendment that was passed, planning case 1544-T-94 from 1933, that created the position of the Boneyard Creek Commissioner. It's, an ordinance here. And, I mean, we may want to, review this document and review the items that Libby generously brought forward to our attention, and maybe just take what's already perhaps part of our legal structure and just, kind of modify some of the definitions and expand certain sections. But I think I think it's ultimately going to benefit the community and the city. And I don't have, I know that the process we're going through now is carefully handled. I just don't think it's quite the right process.
Diane.
Well, I generally support the intent behind this, these discussion topics, and especially for me, I think I never could, well, first of all, I'll admit, I didn't even really know anything about the Boneyard Commission until 3 or 4 years ago when our specific project appeared across the street from a property we owned. And then I realized, as I learned more about it, that major buildings, major developments can be built in this Creekway district without the same sort of oversight or process that other projects anywhere else in the city would have to go through, especially when they're asking for these bonus provisions are major variances. And so I never understood why a building in this district should be exempt from the same level of public participation and review as any other project in the city. So I don't think we're asking for any more, anything different. I'm just thinking, I think every development should be treated the same, with the understanding that yes, it's in the Boneyard district, and we want to protect the creek. So I think this is worth a discussion. Thanks.
Libby, did you want to say something?
Well, yes, in the interest of transparency, I think it's good to have these discussions in terms of goals that, could be achieved in a council-directed text amendment, but the specifics of it to deal with property rights, we need to have that in the hearing context of the Plan Commission, who holds hearings on text amendments. We'll notice people. We've got a couple hundred properties that are affected by any change in the procedures. So I just wanted to, I know we're talking generally now, but to talk specifics without the protection of that hearing from the Plan Commission, because we are talking about the zoning ordinance, I think that that would be appropriate down the road. We do have some other mechanisms where we have like tiered processing. Actually, HPC reviews most things, but there's a category called minor works. And I think Charlie was alluding to the MOR, which also has an administrative tier. So that might be one approach that could be used in the Boneyard. But I just wanted to caution the council. I understand, I can kind of understand where the sense of the council is going, and there's planning goals here as well as development goals. And I think that we can achieve both, but it wouldn't be proper to do that all at the council floor. I think that there's work to be done at the staff level to prepare this, then to get guidance, and then the Plan Commission has their role with the public input, and then of course any changes would come to the City Council.
So this is the only place where there's bonus points? Is on the Boneyard? Because of the ordinance, the way the ordinance was adopted.
The MOR has some incentives. We try to incentivize their adaptive reuse, historic preservation. Again, these overlay type zones, we try to, soften the blow a little bit by offering some goods in exchange for benefits that the city wants. PUDs is huge, but none of that's administrative. So, we do have a complicated zoning ordinance, and it evolves, and there is absolutely no problem in modifying a process, improving a process. That's done all the time. You hear text amendments constantly. Even tonight there was a text amendment. So there's a process. Establishing a new commission, that's a little bigger deal because there's staff resources that go into that. I know community development has a dozen, 12 right now. This would add. One thing we're considering with the downtown design guidelines, which we're working on now at the very preliminary stages, is can we combine our design review boards? Because that would bring the total to 4 areas where we have that extra design review. So we do have a lot of bells and whistles in our zoning ordinance. I completely agree on the need for, refresh planning look at the Boneyard, since we're working with such an older plan. I think that would benefit. And there's definitely some great people out there who could assist. I don't think staff would recommend a hybrid board. I know some cities have hybrid boards with staff members and council members. I think it should be, if we do go down the path of reestablishing the Boneyard Creek Commission, it should be people with an interest in technical expertise, because again, we have that process. Staff plays a role, commissions play a role, council plays a role. So to mix those up, I think can make things more complicated sometimes.
Eric.
We're relatively early in this discussion, but I think based on what I've been thinking and hearing, although it's a big deal, I would favor, I think, the establishment of a commission because this area is so unique. It's got unique building challenges, it's got unique features, and I think a commission that was freestanding on this could actually take a proactive role in creating, in updating and fleshing in the master plan.
Okay, so we could, the staff has a lot of stuff to do, but, put it on the list and bring back a proposal in some kind of reasonable time frame. I'll check with Libby what she finds to be reasonable to get it done.
Well,
Dennis?
and I'm just thinking that in my many off moments of boredom, right? I certainly would be willing to cobble together or thoughtfully put together a couple of basic proposals, or start some writing out as well. It wouldn't have to necessarily be completely in the burden of the staff to handle it. And I don't want to take away any of the responsibilities of the Planning Commission. And maybe if the Boneyard Creek Commission was, adopted by the Planning Commission, and that's another way maybe to consider it. But what I want to see is more of a proactive, creative way of dealing with the question of developing the creek bed, and also just public transparency, I think, is so important.
Okay. Anyone else? Charlie?
Yeah, I was going to make much the same offer as Dennis, is to work on this, and he and I can bounce some ideas, because I think, like I said, I'm looking for a way to revise this. This is a starting point. The existing zoning ordinance piece is where you would start, and then figure out, based on what Dennis and I have put together and what others have said tonight, the framework that Eric refers to is a nice way to think about it. How do we make that framework out of these various documents and comments? And I don't know that it will be terribly difficult, but it will be complicated. It's already complicated.
Eric?
To the extent that we can do it consistently with the Open Meetings Act, I'm willing to help you two guys.
Okay, so, I mean, this will take a while, with input from a lot of people, so we'll start working on it. Anyone else?
Just thank you all for the time you spent listening to my thoughts.
Okay. There being no further business, this meeting is adjourned. Thank you all.